Hello, in today's video we will take a look at personal bankruptcy. If this is your first time here, my name is Unwana Udoh. Every week, I share strategies you can apply to improve your personal finance and grow your wealth. Before we continue, hit the subscribe button and the notification bell so YouTube will notify you of my latest videos. The most difficult decision that you can face is whether or not to file for bankruptcy. For individuals, there are two types of personal bankruptcy, Chapter 7 and Chapter 13. Designed to give you a fresh start in life by wiping out certain debts. A Chapter 7 bankruptcy will get rid of credit cards and other unsecured debts. A Chapter 13 bankruptcy, on the other hand, is a court-approved payment plan in which the filer is required to repay a predetermined percentage of their debt. The determination of which chapter to file will be based on the filer's disposable income, if any, after paying their necessary monthly bills. When many people file for bankruptcy, their first thoughts are of their assets and whether or not they may lose their home. In a Chapter 13 repayment plan, most filers are allowed to keep their property in exchange for repaying a portion of their debts. Chapter 7, however, is designed to be a liquidation process that often results in the sale of non-exempt property. Which property is non-exempt in a bankruptcy proceeding? Each state has its own laws pertaining to the amount of property that an individual or married couple can keep without having to worry about it being liquidated. The official bankruptcy process begins upon filing a petition with the local bankruptcy court. This can either be done individually, also known as pros, or with the help of an attorney. Hiring an attorney is the best way to make sure that every form is completed accurately and in order to make sure your assets are protected. Upon the filing of a bankruptcy petition, the court will assign a trustee to the case and set a date for a meeting of the creditors. Although creditors are invited to attend, they are not required to do so. The filer, however, is required to attend and will be questioned by the trustee, under oath, while having the meeting recorded. This meeting is typically the only appearance required of the filer unless special circumstances are present. Following the meeting of the creditors, often referred to as the 341 meetings, the creditors will have 30 days to object to the filer's property exemptions and another 30 days to object to the discharge if the filing is a Chapter 7 bankruptcy. In a Chapter 13 proceeding, creditors may object to the payment plan but the discharge will not be granted until the payment plan is complete. A Chapter 13 bankruptcy can last for up to 5 years before the payments are completed and a discharge is issued. Following the discharge, the bankruptcy case will be closed and the process will be complete. This video is only for informational purposes only. It should not be used as, in place of or in conjunction with professional legal advice regarding bankruptcy. Anyone who is considering filing a petition for either personal or business bankruptcy should consult a licensed attorney in their area for additional information and legal advice. Declaring bankruptcy does not mean that an individual's subsequent access to credit is cut off. Whether a debtor is allowed to keep credit cards after filing bankruptcy is up to the credit card company. If the bankruptcy involves discharging a credit card, the card company will cancel the card unless the debtor reaffirms the debt. Even if the card has a zero balance, the credit card company might still cancel the card. A number of banks now offer secured credit cards, in which the debtor puts up a certain amount of money, as little as $200, in an account at the bank to guarantee payment. Initially, the credit limit is equal to the security given and is increased as the debtor demonstrates the ability to pay the debt. 2 years after a bankruptcy discharge, debtors are eligible for mortgage loans on par with applicants of the same financial profile who have not filed for bankruptcy. Income stability and the size of the down payment are seen as more relevant than a past bankruptcy filing. Though bankruptcy stays on a credit report for 10 years, it becomes less significant as time passes. People who have filed for bankruptcy are often better credit risks than people who have not, and are struggling to pay multiple accumulated debts. Debtors filing for bankruptcy are allowed to keep certain assets. The exemption for a homestead is limited to $125,000 if the property was acquired within the previous 12-15 days, 3.3 years. The cap is not applicable to any interest transferred from a debtor's previous principal residence which was acquired prior to the beginning of the 12-15-day period. The value of the state homestead exemption is reduced by any addition to the value brought about on account of a sale of non-exempt property made by the debtor with the intent to evade or defraud creditors during the 10 years before the bankruptcy filing. An absolute $125,000 homestead cap applies if either the court determines that the debtor has been convicted of a felony demonstrating that the filing of the case was an abuse of the provisions of the Bankruptcy Code, or the debtor owes money due to criminal acts. This limitation is not applied if the homestead property is reasonably necessary for the support of the debtor and any dependent of the debtor. Some laws relating to bankruptcy vary from state to state. Legal residency is determined by which state the debtor lived in the 730 days, 2 years, before filing, or if the debtor did not live in a single state in the previous 2 years, the state of residence where the debtor spent the majority of the 180 periods preceding the 2 years. If this leaves the debtor ineligible for any exemptions, then the debtor is allowed to use federal exemption laws. In some cases of Chapter 7 bankruptcy, tax debts are also wiped out, but only if stringent conditions are met, such as, the IRS does not have a tax lien against the debtor's property, no fraudulent tax returns have been filed, tax liability is due for a tax return filed at least 2 years before the bankruptcy filing, the tax return was due at least 3 years ago, and the taxes were assessed at least 8 months before filing for bankruptcy. Student loans from government and private organizations are usually not wiped out unless repayment would cause undue hardship to the debtor. All non-exempt property, such as real estate, cars, and motorcycles, will be liquidated by the trustee. There is no legal requirement to use a lawyer to file for bankruptcy, and debtors can do so themselves for about $300. However, it is strongly advised the use the services of a specialized bankruptcy lawyer as bankruptcy law is complex. A bankruptcy lawyer is well worth the cost, which is usually only $1,600 to $2,000. Debtors will recoup the legal fees many times over through peace of mind and avoid stress, in addition to actual money saved by following the bankruptcy attorney's advice. We are currently experiencing a global health pandemic that has impacted a vast number of families. Unfortunately, after all said and done, there will be individuals that may face the possibility of bankruptcy. If you found value so far, hit the like button and share this video with friends and family. The next video on the screen contains information you will love. Click to watch that video now and I will see you there.